Okay, so what are rights of appeal from legislative and administrative courts? As we previously discussed, these are special courts that don't fall under Article 3. They're specially created by Congress under the authority of the president or independently. So the administrative courts have the authority to adjudicate disputes under their regulatory regime. And legislative courts are specific purpose courts like military or tax or immigration or something like that. So, to where did these courts appeal? Generally, legislative and administrative courts especially administrative courts, they have to go through a process of appealing within the administrative agency. Okay? Now, if all else fails to resolve the issue within the administrative agency, then the individual appealing the administrative court's decision can appeal to the state or federal trial court with general jurisdiction in its area. Okay, so a matter from the bankruptcy court may be appealed to a federal district court. And while this is a trial court, it acts somewhat as an appellate court. It looks to see whether the law was applied correctly and whether the decision of the court in some way violates constitutional rights. So it follows more appeal of the administrative procedure and whether the issue was adjudicated correctly. So in this way, the trial court actually acts like an appellate court. Now, in limited circumstances, there may be a statute in place that says appeals from these legislative or administrative courts just jump over the trial court and are appealed directly to the Circuit Court of Appeals or the state intermediate appellate court. In that situation, they would move past the trial court and appeal directly there. But in most scenarios, there's a direct appeal route, again, to the trial court who acts in more of an appellate function. So it's a completely alternative role for the trial judge in that scenario.